What happens to your loved one's home when they pass away? Well, really, it depends on how they owned that home. So first thing we have to look at is the deed and how it is titled. If they owned that property, let's say with a spouse, and they owned it as husband and wife, well, nothing needs to happen. Their death certificate just needs to be recorded and the surviving spouse will assume their interest. Let's say they owned the property this time joint, but with a non-spouse. If they owned that property as joint tenants with rights of survivorship, same thing, nothing needs to happen necessarily. All they need to do is file their death certificate, and that interest gets assumed by the other owner. However, if they own a property jointly with someone else, but it doesn't have that rights of survivorship language, well then their interest, whether that's 5%, 50%, that interest needs to be probated before it can be transferred to their beneficiaries or heirs. And same situation if they own the property by themselves. If they own that property and it's in their name alone, no one else is on the deed, that property must be probated before it can be transferred to their heirs or beneficiaries. So that probate process will have to take place before it can be sold, before it can be transferred. And that is a court process that needs to happen where a judge will sign an order transferring that property to their heirs or to their beneficiaries per their will.